Welcome back to the deep dive. Today we are heading into some pretty dark territory. I want you to imagine a scenario, one that feels like it's been ripped straight out of a nightmare, or maybe the cruelest moral philosophy exam you've ever taken.
Yeah.
Picture this. It's 2 in the morning, it's pitch black, raining heavily. You are standing on the side of a highway. You watch a man get hit by a car. He is lying in the middle of the wet asphalt, helpless, unable to move. You have a cell phone in your hand. You have full service. You could save his life with a single button press calling 911. But you don't. You just stand there. You watch. And because you do nothing, that man dies alone in the rain. So here's the question that keeps lawyers up at night. Can you be sued for that?
It is a terrifying question. And it strikes the very core of what we think we owe one another. I think for most people listening, the gut instinct is immediate. Of course you should be liable. That's monstrous.
Exactly. It feels like a total abdication of humanity. But we aren't here to talk about moral failure today. We are here to talk about legal liability. Does the law actually force you to be a good person? Or does it, protect your right to do absolutely nothing?
The answer is surprisingly complex and frankly a bit disturbing until you really dig into the logic. So for this deep dive, we're going to navigate this legal minefield. We have a very specific roadmap. First, we need to look at the traditional common law rule regarding nonfeasance or, doing nothing.
Okay.
Second, we're going to dissect a landmark case, Podias v. Mairs, to see how modern courts are analyzing this. And third, we'll break down the specific four-factor balancing test the court used to determine when a duty to act actually exists.
Let's start with the basics, the foundation, because I think a lot of us assume there is some good Samaritan law that forces us to help. Under the traditional common law, is there a general duty to rescue a stranger in peril?
No. That is the general rule, often called the innocent bystander rule. The black-letter law is very clear here. Generally, there is no independent duty of rescue. A bystander has no legal obligation to provide affirmative aid, even if they have the ability to help, and the cost to them is negligible.
That feels incredibly harsh. I mean, if I see a toddler drowning in a shallow pond and I can just lift them out without even ruining my shoes, the law says I can just keep walking. Why does the legal system protect people who just stand there?
It creates a lot of tension, doesn't it? But the legal reasoning relies on a sharp distinction between misfeasance and nonfeasance. Misfeasance is active misconduct. You pushed someone into the water, you drove drunk, you created a risk. The law punishes that because you made the world more dangerous.
Oh, you did something.
Exactly. Nonfeasance is passive inaction. The legal rationale is that by doing nothing, the bystander has made the situation, well, no worse.
No worse. The person died.
True. But legally speaking, the bystander didn't cause the drowning. They simply failed to stop it. The law has historically been very hesitant to force people to act, because where do you draw the line? If you have to save the toddler, do you have to donate a kidney to save a dying stranger? The law prioritizes individual liberty over mandatory altruism.
Okay, I see the slippery slope argument, even if I hate it. But surely the rule isn't absolute. You can't always just walk away. When does a duty arise?
You're right, it's not absolute. There are traditional exceptions where the law steps in and says, no, here you must act. First, if there's a pre-existing legal duty, like from a statute or a public calling, like a police officer on duty. Second, if the actor created the peril in the first place, even if it was innocent. Third, if the actor volunteers assistance, they try to help, but then they do so negligently and make things worse.
So if you start to help, you have to do it right. What about the fourth?
And the fourth is crucial for our deep dive today, the existence of a special relationship between the parties.
Okay, hold on to that concept of relationship, because that is where this gets messy. It's easy to say a parent has a relationship with a child, but friends in a car. Let's transition to our case study to test these rules. We're looking at Podias v. Mairs. This is a New Jersey case that really pushes the boundaries of that innocent bystander defense. So let's analyze this. First, what are the legally dispositive facts?
The facts are tragic, and honestly, they're infuriating. The case involves a driver, Michael Mairs, and his two passengers, Swanson and Newell. All three were 18 years old. Mairs had been drinking beer. It's 2:00 a.m., raining, the road is wet, they're on the Garden State Parkway. Mairs loses control and strikes a motorcycle driven by Antonios Podias.
Okay, so just to be clear, Mairs is the driver. He hit the guy. But we're focusing on the passengers, Swanson and Newell. What happens right after the crash?
So the car goes over the guardrail. All three get out. They're huddled by the car. Swanson, one of the passengers, sees the victim, Podias, lying in the roadway. He sees no movement. He tells the others he thinks Mairs killed him. Crucially, at this moment, there are no other cars, no witnesses. just darkness and rain.
So they are the only ones who know he's there. The guy is lying in the middle of a highway at 2 in the morning. Do they call for help?
No. And this is the critical part about opportunity. All three had cell phones. But nobody calls 911. Mairs calls his girlfriend because his phone is lost, so he uses Newell's phone. Swanson uses his phone to make 17 calls over the next hour and a half.
17.
17. And Newell's phone is used to make 26 calls.
Wait, hold on. They made 43 calls between them. 43 calls to girlfriends, friends, whoever, but not a single one to emergency services.
Correct. Not one. Swanson later testified he didn't feel responsible. Newell said he didn't want to get in trouble. They were worried about the cops finding out they'd been drinking underage.
Unbelievable.
After about 10 minutes, they decide to flee the scene. They get back in the car. Mairs drives a short distance until the car breaks down, and then the passengers, Swanson and Newell, run into the woods to hide.
That is just chilling. Leaving him there like roadkill so they don't get a ticket for underage drinking. And what happens to the victim, Mr. Podias?
While he is lying helpless in that dark, rainy road, another car driven by a woman named Patricia Uribe runs over him. Podias died as a result of the injuries from these accidents. The medical examiner couldn't even determine if the first or second impact was the one that killed him.
Brutal. Okay, the victim's family sues. Obviously, they sue the driver, Mairs, but they also sue the passengers, Swanson and Newell. And the passengers essentially say, hey, we didn't hit him. We were just sitting there. We're innocent bystanders. So what was the core legal issue for those passengers?
The issue is this. Does a passenger in a vehicle owe an independent duty to a pedestrian struck by the driver, specifically when that driver is unwilling or unable to seek aid?
It seems like a new frontier for liability. So, what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied a totality of the circumstances test. This is derived from a precedent case called JSVRTH, and the rule balances 4 distinct elements to determine if a duty exists. Those elements are, first, the nature of the underlying risk, specifically its foreseeability and severity.
Okay.
Second, the opportunity and ability to exercise care. Third, the relationship between the parties. And fourth, public policy and fairness.
Thank you. This is the framework we need. Now for the court's elemental analysis. Let's walk through this step by step to see how they dismantled the passenger's defense. How did the court apply the first element, foreseeability and severity of harm?
Right. So the court started by analyzing the risk itself, which in this case was, well, death. The court found this risk was readily and clearly foreseeable. In applying the facts, the court noted that the defendants knew the victim was lying helpless on a dark, wet highway in the middle of the night.
They saw him there.
Exactly. And furthermore, they were in a unique position. They knew Mairs, the driver, would not call for help.
Why did they know that?
Because they knew he was intoxicated. They knew he had just committed a hit and run to save his own skin. They knew the driver was compromised and was only acting in his own self-interest. So the conclusion for element 1 was that the risk of further harm was obvious and foreseeable to the passengers. Element met.
Understood. So they can't claim ignorance of the danger. Now, what about the second element, opportunity and ability to exercise care?
Here, the analysis just focuses on practicality. Was preventing the harm difficult? The application of the facts is damning. As we said, all three had cell phones. They used them constantly for their own purposes, calling girlfriends, checking in. The court noted that calling 911 would have been a simple precaution at little if any cost. They weren't asked to run into traffic or perform CPR.
Just make a phone call.
Just make a call. The conclusion for element 2 is that they had both the control and the opportunity to prevent the harm. Element met.
Now we get to the hardest part. The third element, the relationship between the parties. The defense argued they were just passengers, strangers to the victim, strangers to the event. They weren't driving. How did the court handle this?
This is the real pivot point of the case.
Yeah.
And where the court expands the law. The court flat out rejected the innocent bystander label. In its analysis, the court looked for a nexus, a connection. Applying the facts, the court found they were part of a common undertaking.
A common undertaking? What does that mean?
It means they were in it together, drinking together, driving together. The court called the car the instrumentality of injury, operated for their mutual benefit.
Instrumentality of injury. That is a heavy phrase. It sounds like the court is saying they were part of the weapon.
That is a great way to put it. The court said they acquiesced in the conditions that created the risk. They were riding with a drunk driver. They were part of the group dynamic that led to the accident. Even though they didn't hold the wheel, they were part of the team that night.
I
So the conclusion was that a sufficient nexus existed to distinguish them from random strangers on the street. Element met.
That distinction is vital. They weren't just random people walking by, they were inside the event. Finally, the fourth element, public policy and fairness.
The analysis here is about societal values. Does society benefit from imposing this duty? The court looked at things like the Good Samaritan Act, which protects volunteers. The court reasoned this shows a legislative intent to encourage aid. Applying this to the case, the court stated that common decency dictates action in such extreme circumstances.
So it's about what we expect from each other as human beings. If the law lets you get away with this, the law itself is broken.
Precisely. The conclusion was that imposing a duty here offends no notions of fairness. It aligns with public policy. Element met.
And after analyzing all the elements, foreseeability, opportunity, relationship, and public policy, what was the court's final conclusion?
The court reversed the summary judgment. Now, they did not say the passengers were definitely guilty, but they ruled that a reasonable jury could find that the defendants breached a duty to the victim. The case was remanded for trial. They can't simply walk away claiming no duty.
That is a massive shift from the innocent bystander rule we started with. It feels like the court is saying, if you are part of the mess, you have to help clean it up.
It is. It's a signal that the law is moving away from rigid categories and toward a standard of, general fairness.
I want to really test the limits of this ruling because I can hear some of our listeners worrying, wait, if I see a car crash, do I have to stop? Let's throw a visceral hypothetical at you to see where the line is.
Go for it.
Scenario. A man is walking down the street. He sees a heavy flower pot fall off a third-story ledge. It hits a pedestrian in the head. The pedestrian is knocked unconscious, bleeding profusely on the sidewalk. The man walking by has a cell phone. He's the only one around. He looks at the victim, shrugs, checks his watch, and keeps walking to get a coffee. He does nothing. The pedestrian dies. Is the man liable under the Podias ruling?
No, he's not liable.
Oh, wait. He had the phone. He had the opportunity. The harm was foreseeable. The guy was bleeding out. Why is this different? The moral outrage feels exactly the same.
It creates a moral outrage, certainly, but not legal liability. And it comes down to that relationship element we just talked about. In your flower pot case, the man is a true innocent bystander.
Yeah.
He has absolutely no relationship to the flower pot, the building, or the victim. He didn't create the risk.
And he wasn't involved in the activity that caused it.
Exactly. Contrast that with Podias. The passengers were inside the weapon, the car. They were friends with the shooter, the driver. They were participants in the night's events. That connection, that nexus, is what triggered the legal duty. In the flower pot case, there's no nexus.
So the instrumentality concept really is the key. In Podias, they were part of the machine that caused the damage. In the flower pot case, the bystander is just a witness.
That's the perfect way to phrase it. It moves you from stranger to participant, even if you weren't the one driving. The law won't force a stranger to be a hero, but it might just force a participant to be a human being.
Okay, this has been a lot to unpack. For our listeners who might be using this to spot issues, maybe on a torts exam, let's synthesize this. Give us a diagnostic checklist. How do we analyze a failure to act problem systematically?
Right, so if you see a fact pattern where someone does nothing, nonfeasance, and someone gets hurt, use this framework. Step 1, identify nonfeasance. Ask yourself, is the defendant being sued for doing nothing? If yes, proceed.
Easy enough.
Step 2, default to no duty. Start with the premise. Generally, there is no duty to rescue. You have to acknowledge that baseline first. Step 3, check statutory or formal exceptions. Is there a specific law? Are they a parent, a spouse, an employer? If yes, duty exists. If no, move to step 4.
And step 4 is the big one.
Step 4 is the Podias fairness test. This is where you argue for an ad hoc duty. You need to verify 3 main things. First, foreseeability. Did they know the risk was severe? Second, capacity. Could they help easily, like with a cell phone? And third, nexus. This is the big one. Were they involved in the event that caused the danger? Were they inside the instrumentality or part of the common undertaking?
Got it.
And finally, step 5, a policy argument. Conclude by asking if common decency demands a legal remedy here.
That step 4 seems to be where the battle is really fought.
Absolutely. That nexus or relationship factor is where you win or lose the argument. If you can prove they were part of the chain of events, you can pin a duty on them.
So what does this all mean for us? What's the takeaway?
It means the era of the hands-off bystander is shrinking. If you were part of the chain of events, even if you didn't pull the trigger or steer the car, You can't simply wash your hands of the consequences.
Being a passenger isn't a free pass anymore.
Not anymore. If you're part of that common undertaking, you share some of the responsibility for the aftermath.
That is a powerful takeaway. The law is essentially saying, if you are part of the problem, you have a legal duty to be part of the solution. Or at the very least, you have duty to pick up the phone.
A single phone call. That was the difference between walking away and being a defendant in a wrongful death suit.
Something to think about the next time you're in a car with friends and things start to go south.
Yeah.
That wraps up this deep dive into Podias v. Mairs. Thanks for listening.